Thank you for joining the webinar on the JCT 2016 edition suite of contracts. There will be time at the end of the webinar to ask any questions that you may have. Any follow-up questions can also be sent to us following the webinar. You will find Connor and my email address on the last slide. Our colleagues are also speaking on the NEC 4 changes on the 11th of July, which you may also want to sign up to. Details of this webinar are on the website. So this webinar provides an overview of the key features of the JCT 2016 edition contracts, changes to the payment provisions, the loss and expense provisions, the insurance provisions, and security provisions. The talk also provides an overview of what to consider when using the JCT 2016 edition of contracts. So the JCT has now issued updates to the entire suite of contracts. Whilst the changes are not as far-reaching as those brought about by previous editions, there are some important, and we consider helpful, amendments to the suite. JCT have now updated all the building construction contracts and subcontracts, agreements, and collateral warranties. JCT have also produced 2016 guides to accompany each form of contract agreement. Track change documents showing the differences between the previous 2011 edition and the current 2016 edition are also available to be downloaded from the JCT website. JCT 2016 supersedes JCT 2011, but JCT 2011 will continue to be available during a transitional period. From April 2018, the JCT 2011 contracts will no longer be in use in any format. As a firm, we are already using the new contracts for clients on projects presently being procured. The majority of changes to the 2016 suite of contracts reflect case law and legislation that has come out over the last 5 years. The changes also reflect current government BIM and fair payment initiatives. Current bespoke schedules of amendments in place and currently being used with the 2011 suite would not be applicable to the 2016 suite of contracts. Parties should therefore make sure that they are using an appropriate schedule of amendments before they enter into the new 2016 edition form of contracts. As set out in the overview slide, Connor and I will be discussing the main changes to the payment provisions, loss and expense, insurance, collateral warranties, and forms of security. But before we discuss these main changes in detail, I'm going to discuss some other changes introduced by the 2016 edition that you may or may not have come across on your projects to date. So the first change is to the CDM Regulations 2015. Following the introduction of the CDM Regulations 2015, an amendment sheet was published in March 2015 by the JCT, and that was appended to the 2011 suite of contracts. These amendments are now fully integrated into the 2016 edition contracts. Although the new CDM regulations take quite a different approach, the 2016 edition amendments are relatively minor. The most significant of the changes is the replacement of the role of the CDM coordinator with the role of the principal designer. You should all be familiar with this change, but as a quick reminder, principal designers are required to be a designer with control over the pre-construction phase of the project. Another change is that the construction phase plan, and that's a term defined in the contracts, has a revised statutory definition. As there is no longer a requirement to identify a CDM planning period in the CDM Regulations 2015, this entry in the contract particulars has now been removed. Another change is in relation to the Public Sector Supplement 2011 and the Public Contract Regulations 2015. So the 2016 edition contracts have been updated to reflect the Public Sector Supplement provisions, and that's in relation to fair payment, transparency, and BIM, and they also incorporate various aspects of the Public Contracts Regulations 2015. In the 2016 edition, the provisions included in respect of the Public Contract Regulations only apply where the employer is a local or public authority and the contract is subject to the Public Contract Regulations. As well as being used by public bodies, this update will also apply to contractors and subcontractors who are engaged to act on public sector building projects. Provisions to note which are included by the Public Contract Regulations in the 2016 suite are Regulations 57, 71, 73 and 113. So Regulation 113 relates to prompt payment. This regulation requires that employers pay valued and undisputed invoices within a 30-day period. There is also a requirement to ensure that invoices are considered and verified in a timely fashion. There's also an obligation on contracting authorities to ensure that the subcontractors abide by the conditions and that the terms are passed down the supply chain. So it's important to note that where a public contract doesn't provide for these requirements, they are deemed to be included, and this means that the obligations cannot be contracted out of. JCT's payment provisions, if they are unamended, already allow for a 30-day payment period, and so no specific amendments are required in this respect. There are, however, provisions at each tier that refer to Regulation 113 and require that the payment terms are passed down to the supply chain. So Regulation 71 relates to subcontracting. Under Regulation 71, the contractor must provide the employer with basic information on the contractor's immediate subcontractors, and that may be extended to any lower tier subcontractors that the contractor has. Regulation 57 gives the employer the right to insist on the removal of a subcontractor where there are grounds for exclusion in accordance with the regulations. And finally, Regulation 73 requires public contracts to contain the right for the employer to terminate the contract where there has been a substantial modification to the contract within the meaning of Regulation 72. The contractor should have been excluded under Regulation 57, or the contract should not have been awarded due to a serious infringement under European law, as declared by the Court of Justice in infraction proceedings. So in addition to the right to terminate the contract under any of these three circumstances, the 2016 edition includes appropriate provisions to deal with the consequences of termination in each of these individual cases. The 2016 edition has had minor updates to the intellectual property provisions, with the JCT 2012 Name Specialist update being inserted. The copyright license is now expressly assignable to any owner from time to time of the works. The copyright license may also be sublicensed to any owner or tenant or to any person engaged in any of the permitted purposes referred to in the main license clause. There have also been changes to BIM. To reflect the increased use of BIM throughout the construction industry, and also following the issue of the JCT of its practice note, Building Information Modelling, Collaborative and Integrated Team Working, the 2016 edition contracts incorporate specific contract options in relation to BIM. So the 2016 edition has introduced a BIM protocol, which is intended to be included in the employer's requirements. The BIM protocol forms part of the contract documents and requires the contractor to carry out works in accordance with that BIM protocol. It should be noted that the BIM protocol supports the main contract document in achieving BIM Level 2 only. So this means that the 2016 suite will therefore need bespoke amendments if you want to achieve higher BIM levels. So I'm now going to be discussing the major changes to the payment provisions and regime. So JCT have made widespread amendments to the payment provisions. The changes are designed to reflect fair payment principles and also to simplify the payment provisions. In the 2016 edition contracts, if they are operated properly, they will also speed up payment for the subcontractors and sub-subcontractors. Under previous JCT editions, it is and was usual for the subcontractors and sub-subcontractors to have to wait for their payment application to be included in the contractor's upstream payment to the client. And this had the effect of delaying downstream payment by a month. So if the payment provisions are unamended in the 2016 editions, payment will be made from the top to the bottom of the chain within 30 days. If you are making bespoke amendments to the standard forms of contracts, care should be taken to carry out any bespoke amendments in the main contract through to any subcontracts and sub-subcontracts to avoid creating an inconsistent payment regime. So over the next couple of payment slides, I've used the JCT Design and Build 2016 edition contract as an example. The main changes include the following to the payment provisions. So the interim valuation date, a monthly payment cycle from practical completion to the date of final payment, the final payment notice, unpaid amounts being recoverable as a debt, and fluctuation provisions. So the first change to the payment provisions is the interim valuation date. JCT have introduced the concept of a common interim valuation date. This date is the same in the main contract, the subcontract, and the sub-subcontract. This change improves the speed at which the subcontractors and sub-subcontractors get paid. Under the main contract, the parties would choose the first interim valuation date, and that date is stated in the contract particulars. Subsequent interim valuation dates will be the same date in each month or the nearest business day in that month. If the parties do not choose the first interim valuation date, the default position is 1 month after the date of possession. The interim valuation date will apply for both Alternative A, stage payments, and Alternative B, periodic payments. Practically, if the interim valuation date falls, for example, on a Saturday, the interim valuation date by default would be the Friday, as this would be the nearest business day in that month. Alternatively, if an interim valuation date fell on a bank holiday Monday, the closest business day would be a Tuesday. So due to the changes in counting days, this will affect the due date and the 5-day period for the issue of the payment notice, the last day for giving a pay less notice, and also the final date for payment. Employers, and in relation to subcontracts, contractors, should bear in mind the importance of serving payment notices and payless notices on time to avoid losing the contractual right to do so. So the changes to the payment regime to the main contract are shown in the table on the slide. In the example on the slides, the interim valuation date chosen by the parties is the 1st of January. The contractor can make an application for payment at any time before the interim valuation date. The due date follows 7 days later. So in the example on the slides, as the contractor issued his interim application before the 1st of January, and remember that's the interim valuation date, the due date is the 8th of January. The contractor makes an interim payment application based on the sum that the contractor considers to be due to him at the due date, and that's the 8th of January in our example, and the basis on which that sum has been calculated. Where the interim payment application is received by the employer later than the relevant interim valuation date, the due date shall be 7 days after the date of receipt by the employer. Not later than 5 days after each due date, the employer must give a payment notice. If no payment notice is given, the contractor's interim payment application operates as the payment notice. So in our example on the slides, the employer must issue a payment notice on or before the 13th of January. The payless notice is due no later than 5 days before the final date for payment. The final date for payment is 14 days following the due date. The 14-day time period applies to both the interim payments and the final payment. So the final date for payment under the previous edition was 28 days from the due date. In our example on the slides, the final date for payment of the interim application is the 22nd of January. So the changes to the payment regime in the subcontract and sub-subcontract is shown on the table on the slides. Under the subcontract, the interim valuation date is the same, i.e. the 1st of January, so the same date as in the main contract. There is the option to require the subcontractor to submit its payment application at least 4 days prior to the interim valuation date to ensure that its application for payment is included in the contractor's application upstream to the client. The final date for payment has been shortened from 21 days following the due date to 14 days to take into account the pushback due date. The due date is 12 days after the interim valuation date, i.e. the 13th of January in our example. So this means that the main contractor has 5 days after being put in funds to make payment to the subcontractor. In our example on the slides, the final date for payment of the interim application is the 27th of January. So under the subcontract, the valuation date is the same as the interim valuation date in both the main contract and the subcontract, so the 1st of January. Again, the final date for payment has been reduced from 24 days to 13 days to take into account the extended due date. The due date is 17 days after the interim valuation date, and that's the 18th of January in our example. So this means that the subcontractor has a period of 4 days within which to pay the subcontractor after having itself received funds from the contractor. So in our example on the slides, the final date for payment of the interim application is the 31st of January. On the slides, I've included a summary of the payment cycle in the form of a diagram, which effectively summarizes the payment cycle. So the next change to payment is the monthly payment cycle. Previously, interim payment dates would continue up until practical completion, or the specified date within 1 month thereafter, continuing after practical completion at intervals of 2 months. Now, practical completion does not alter the frequency of valuations. The valuations continue right up until the final certificate at monthly intervals. So the aim behind this amendment is to encourage good project account management both before and after practical completion. Practically, it's really important that whoever is dealing with the final accounts knows the dates they are working towards under the revised final account payment timetable. Another change is the final payment notice. The JCT 2016 edition have introduced another notice, the final payment notice. Under clause 4.8, not later than 5 days after the due date for the final payment, and notwithstanding any dispute regarding the relevant statement, the party who is due the final payment must give a final payment notice to the other party stating the sum that the paying party considers to be or have been due at the due date, and also the basis on which that sum has been calculated. It's important that parties are aware of this final payment notice to ensure there are no delays in relation to payment of the final payment. The contractual requirements of the payment notice and pay less notice remain the same as in the 2011 edition. Helpfully, the 2016 edition now expressly clarifies that a payment notice, final payment notice, pay less notice, or final statement is required even if the sum or the amount is 0. Unpaid amounts are now recoverable as a debt. Under clause 4.9.7, the payee may recover any unpaid amounts and any interest on such amounts as a debt. It should be noted that the payee's right to interest is without prejudice to the payee's other rights, including suspension and termination for non-payment. Whilst we will have to wait and see, the effect of this may be to open up summary judgment as a faster means of securing payment and to get cash flow moving on an ongoing project compared to adjudication. So the last change in relation to payment is in relation to fluctuations. The fluctuation provisions have been amended. So the 2016 edition has introduced more flexibility in relation to fluctuations by deleting clause 4.19 of the 2011 edition and including a wider choice in relation to the fluctuation provisions in the contract particulars. Fluctuation options A, B and C can still be selected. However, in the 2016 editions, only fluctuation option A is set out in Schedule 7. JCT fluctuation options B and C are available on the JCT website and can be slotted in. The contract particulars now include an option to select that no fluctuation provisions will apply. The parties can also include a bespoke fluctuation or cost adjustment formula. In our experience, it is usually the case that employers delete all the fluctuation options because low inflation has meant costs have remained either stable or subject to relatively predictable increases. So I'm now going to discuss the changes to loss and expense provisions. The provisions dealing with a contractor's claim for loss and expense have been amended in the new JCT suite of contracts. The 2016 edition continues to provide that the contractor must notify the employer as soon as it appears that progress of the works is likely to be affected. So, under the 2016 edition, the contractor is required to notify the employer of its potential claim for loss and/or expense as soon as the claim becomes reasonably apparent, provide at the same time or as soon as reasonably practicable its initial assessment of the loss and/or expense incurred, and also any further amounts likely to be incurred, together with such information as is reasonably necessary to enable the employer to ascertain the loss and/or expense, and also provide monthly updates to the employer until all information that is reasonably necessary to allow the employer to finally ascertain the total amount of the loss and/or expense incurred by the contractor has been supplied. So in order to be entitled to loss and expense, the contractor must comply with this notification requirement. The 2016 edition has also introduced new deadlines by which the employer must deal with the contractor's loss and expense claims. The employer must now assess claims for loss and expense within 28 days of receipt of the contractor's initial assessment of its entitlement, and within 14 days from any subsequent update to the assessment. The amendments benefit the contractor because the 2016 edition assures that the employer promptly carries out its loss and expense assessment. The amendment also now avoids loss and/or expense claims being raised at the end of the project. The 2016 edition does not make provision for the employer to be able to defer the determination of the loss and expense claim until the actual loss suffered by the contractor is clearer, and it is not clear whether the employer could later challenge the amount awarded. The drafting in the 2016 edition could be interpreted as the employer having to make a determination at an early stage in all cases, and that determination being final, which is likely to be detrimental to both the employer and the contractor. So our recommendation is that employers seek advice on amending the 2016 edition to ensure that they have the express right to defer and also to challenge such loss and expense assessment. Employers will also need to consider whether these time periods can be achieved on a practical administrative level, and contract administrators will need to be organised and know about these timeframes. The employer may also need to maintain a contingency fund to cover any loss and expense claims. From a contractor's perspective, these provisions should also be clarified in a schedule of amendments. Contractors should also consider what happens if an employer does not adhere to these timeframes.
Thanks, Victoria. I'm going to be taking over from here. I'm going to start off by talking to you about the insurance provisions and what changes we've seen there. Firstly, an apology. Despite the improving weather, I do appear to be harbouring a cold, so if you do hear me stop and clear my throat at any point, I am sorry about that. But moving swiftly on, the changes that we've seen to the insurance provisions are obviously contained within Section 6 of the contract concerning injury, damage and insurance, are widespread, but as I've said there in the slide, they're predominantly not substantive. The overall aim is to just tighten up the drafting a little bit, but also to ensure that the provision is consistent with the revised definitions in the contract. There is, however, one key change that we want to bring to your attention, and that is in insurance option C. This insurance option concerns tenants and their contractors who wish to carry out works in a multi-let property. Usually that would be something like office refurb works. And in the 2011 edition, the requirement was that a joint names policy would be needed to ensure any existing structures. That would obviously be joint names of the employer and the relevant contractor. But a policy of that nature would not always be readily available for certain projects, particularly as the landlord typically owns and insures the building. What I'm essentially referring to there is where you have a need to insure not just one section of a large building that's being worked on, but of course the whole building, because the risk is technically to that whole structure. The landlord would typically insure the whole building, and the tenant you would normally find would lack the necessary information, such as previous claims on the entire structure, to obtain their own insurance policy. It might have been that a tenant could have been named on a landlord's policy, but in fact we've seen an increasing trend of landlords refusing to do that for various reasons, which may leave the contractor actually wholly liable for the insurance of the whole structure, which is just not really an acceptable level of risk when you're only working on a small part. This was the problem that we faced back in 2011, and now we see how they have sought to deal with that issue in JCT 2016. What we've got now is, as I've said, a more flexible approach. It's going to allow the parties to disapply paragraph C1 of Schedule 3 and incorporate their own alternative provisions. You do that at section 6.7 of the contract particulars. But you also set them out in what's called a C1 replacement schedule. There's no set form to that schedule. It's just something that you will have to set out yourself, but you will be prompted within the contract to specify exactly where that schedule is. The sensible approach would probably be just to annex it to the contract itself. And when we refer to alternative provisions, really that's there for the parties to agree. It's what's best for you and it's what's best for the project. So as I've rightfully said there, the alternative provisions you use will likely change depending on the project in question. Different sizes of scheme will obviously suit different approaches. But the JCT amendments essentially seek to increase awareness of the issue. The advice here is when you're in any sort of position where you are agreeing alternative provisions and you are at liberty as such to agree as you wish, as is the principle of contract, you should always take the appropriate specialist insurance advice and be aware of the risks involved in any agreed alternative. Really, if you are getting into a project of this nature, you should be getting advice prior to the tender stage. Have that advice in place early, and if you are in fact the tenant employer in a scenario such as this, you should really be consulting with the landlord and knowing more about their insurance provisions fairly early on. The JCT has quite kindly provided a guidance note that includes some examples of the types of alternative provisions that they're referring to give you a bit of an idea of what you might wish to use instead of what's currently set out in option C. I've just listed briefly what they are. The contractor might cover the risk under their own PL insurance. This will usually only be suitable if the works are of a value that's well within the cover that the contractor can obtain. So you're probably looking at lower value work there. If you step up a notch to higher level works, then there is the possibility of having a system of layered coverage. I suppose an example there would be if the contractor's PL insurance that we've just referred to previously covered up to a certain amount, but then the employer had a special structure insurance, for example, up to a next level, and ultimately the landlord's own insurance covered anything above that, with the employer paying a premium towards the cost. Moving up once again, the landlord might in fact agree where the value is again significantly higher to an insurance level below that of full reinstatement. If you're going to do that, the contractor should really just ensure that they have a suitable cap on their liability. Always important to remember. The other minor changes to the insurance provisions, we have really just a simplifying and consolidating exercise, mostly in Section 6 and Schedule 3. I've listed what they are below in terms of Section 6, but really it's just a case of where things have been dotted around the contract previously, they are now bunched together a bit more consistently, which just really makes for an ease of use and understanding. I've given the examples of it. 6.12, we now have all provisions for providing evidence of your insurance, which is usually requested. 6.13, loss and damage to executed works. The claims procedures arising from that and the obligations to reinstate are now all grouped together in one place. And at 6.14, loss and damage to existing structures and the right to terminate for any subsequent material loss and damage are again grouped together. Really just a sensible approach taken in that regard. Despite the changes that I've listed, one that we might have expected to see but haven't is that there's still no option for the employer to insure the existing structure and the contractor to insure the works, which is in fact a fairly common approach when using option C, and I'm sure one that many of you have come across previously. In that regard, it's just going to be the same as before. Amendments will be required in some form of schedule to make sure that you achieve your necessary effect. That broadly covers what we've seen in the insurance provisions, so we will now move on to changes in the security provisions, starting with bonds and guarantees. So in 2011, there wasn't actually any express provision for employers to request performance bonds or parent company guarantees from contractors. What we're now seeing in 2016, and specifically at clause 7.3, is an obligation on contractors to provide either a bond or a guarantee upon execution of the contract. There's still no templates for those documents, so parties will remain at liberty to agree their own forms, and the forms you've been using up to now with some minor amendments should still be perfectly fine. The clause itself I have set out. I won't read it all the way through, but it's there if you do want to have a quick read through. But the main take home is that the contractor shall provide a performance bond or a guarantee from its parent company upon the execution of the contract. Focusing now specifically on bonds, you will need to detail within the contract particulars whether a bond is required, where the form of that bond is set out, and once again, an annex is probably your best bet. The percentage value of the contract sum, that's the value that will in fact be the value of the bond in question, and the period of validity of that bond if it's not in fact specified within the body. The JCT 2016 contracts also provide optional expiry dates that you may choose between. They're set out in the contract. It is simply either a case of deleting the ones you don't want or marking the one you do. The three they provide are the date of practical completion, 2 weeks after expiry of the rectification period, or the date for issue of the notice of completion of making good. As I say, you can pick your own, but if you don't want to use any of those, you are otherwise at liberty to specify your own date. Carrying on with bonds, should the validity of that bond extend beyond practical completion, the parties may specify within the body of the contract a percentage reduction in the value of the bond at that time. If a percentage is not specified, and this is worth noting, there's a default of 50%, so be careful to specify what you want, because if you do want something higher or lower than that, it will need to be in the contract, otherwise you'll be stuck at the default position. Employers will want to consider whether or not that is acceptable, but in fact so will contractors. It's really going to depend on the nature of the project, as 50% might be unreasonable to either party depending on the circumstances. Moving on to guarantees now. The contract particulars, again, is where we start out, and within there you're going to need to detail, firstly, obviously, whether or not a parent company guarantee is required. If so, you're going to want to say the parent company's name and their registration number, and lastly, where the form of parent company guarantee is set out. Once again, an annex is the best way to go usually. Couple of things to note. Going back to the wording of the clause, which I brought up briefly a couple of slides ago, you'll have noticed that it's a requirement that is shall provide, not must provide, and in fact there's no express sanction within the contract itself if the contractor fails to provide either of the specified documents. That probably won't be acceptable to employers, and they will likely wish to amend the contract to include some express right to withhold payment, or in extreme circumstances to terminate the contract if a required bond or a parent company guarantee isn't provided within the time stipulated. We move on now to third-party rights and warranties. These were previously detailed in Part 2 of the contract particulars. That was obviously back in 2011, but now we see a change where the contract particulars are in fact one document. There's no longer a Part 1 and a Part 2, and instead what we have is something called the rights particulars. This is another separate document from the main body of the contract, and I've said here it is important not to forget to complete it. It would be very easy to forget to complete a separate document, but do make sure you do so, and make sure you incorporate it properly so that it does form part of the contract. If you were to fail to do that, beneficiaries would be left without the benefit of these warranties and third-party rights, which of course wouldn't be desirable. The document itself, the rights particulars, this change reflects an increasing use of own forms to document third-party rights and collateral warranty requirements. So as is kind of a theme throughout the changes in 2016, the JCT have tried to follow what is a current industry practice. Within the document itself, the employer should detail the various rights and warranties required from the contractor, but also from subcontractors as well. Do note that if the employer fails to specify whether it's a third-party right or a collateral warranty that they require, then it will in fact be for the party who's granting either that right or warranty to choose what form they issue it in. So the contractor or subcontractor will then have the choice to either issue a collateral warranty or provide third-party rights. So from an employer's perspective, if you have a preference, it's important to expressly state that. There is a model form, as it's referred to, of this document. You can find it within the JCT guidance notes. It's not mandatory, but it'll certainly give you a good idea of what you might want to include there and how it could look. So do feel free to go onto the JCT website, and I'm sure you'll find that on there. I briefly hinted at just now the provision of third-party rights from subcontractors. This is a new option, obviously to provide rights to the various forms of beneficiary as an alternative to collateral warranties set out in the rights particulars part B. So worth noting that the rights particulars do have a part A and a part B. On receipt of the completed rights particulars, a contractor is to give notice to the subcontractors of any rights requirements of the beneficiaries. This could be done simply by adding a numbered document to the subcontract that details what's required. And we think that although there are these new provisions in respect of third-party rights, despite this, certainly all industry practice indicates that collateral warranties will likely remain the most popular choice. Not least because, as I've said on the slide, it can be easier to grant effective step-in rights, and it does reduce the risk of third-party rights not being incorporated into a subcontract. So yeah, just things to consider there. My final thoughts are on the change in respect of net contribution clauses. Back in 2011, the position was really entirely different to what we're seeing now. I'll briefly touch on what that was. They weren't included in the terms of any third-party rights from the contractor, which were set out at Schedule 5 of the JCT 2011 contracts. And they also recommended removal of the relevant clause from the collateral warranties if you're using a design and build contract. So with specific reference to the design and build contract, the basic thinking behind this was that, as many of you'll know, a design and build contractor has overall responsibility for design and construction of the project. So the inclusion of a net contribution clause might in fact compromise a beneficiary's ability to recover under its collateral warranties. Why is that? Well, effectively the consultant will rely on the contractor being liable for the works as a whole, which is the general intention of the D&B contract, while the contractor will rely on the assumption that's set out within the contract that the consultant has actually paid out. And what you get is a conflict between those two positions and essentially a bit of finger pointing that leaves you with an unclear position, which is not desirable to beneficiaries. In 2016, despite the problems that I've just detailed, there's actually been a bit of a turn on its head. So whereas these provisions weren't included in the D&B contract, they are now in fact in Schedule 5. And the clause is indeed stated to imply in the collateral warranties. So why is that? Why would they do this? As I've said in the slide, it just acknowledges the possibility that the employer's consultants may, in certain circumstances, be jointly liable with the contractor. So why would that happen? Really, we're looking at clause 2.11 here, and it concerns responsibility for the employer's requirements. Normally, the standard position in the contract is that the employer will retain responsibility for the employer's requirements, and in that event, liability could, in theory, fall on their consultants for any mistakes in that document or documents. But as I'm sure you'll all be aware, this clause doesn't normally survive into a final contract without some form of amendment. It's something I will go into a little bit more detail about, but the main point is that as a result of this, net contribution clauses will likely still be resisted by the beneficiaries in any contract of a design and build nature. The regular amendment that I referred to previously, what you really end up with is a position where the contractor accepts a single point of responsibility for both the design and the construction. And then as many of you will know again, design consultants will be novated to the contractor, and responsibility for the employer's requirements will also be passed over from the employer to the contractor. It's a very common industry amendment, but for some reason it's one that the JCT hasn't taken on board, despite sort of an overall trend of making these amendments for that exact reason. And the likely event is that these clauses concerning net contribution clauses will still be removed completely from the document when a schedule of amendments is put together. That covers all the substantive changes that we've come across. So just a summary now of a few key points to remember when you're using the new 2016 suite. First of all, serve your payment notices on time. I'm sure that won't be a shock to any of you, but when we do give reference to the change in counting days that Victoria previously mentioned, it is of increased importance. It should really be, now's the time to review your business processes and update your standard form documents to reflect the changes that we've just discussed. Make sure that the documents that you're using in addition to the contract templates all tally up properly. Touching on what I said about insurance, seek specialist insurance advice prior to the tender stage. If you are a tenant, consult landlords on the insurance arrangements as appropriate. And I think, just as an important point to note, a lot of people are going to be using these contracts for the first time in the very near future, I'm sure. If you are unclear as to how any of these work, do seek the appropriate training. That brings us to the end. If there are any questions or comments that you would like to pass on, do feel free to do so, and we will address those for you now before the end of the session. We still have about 7 or 8 minutes to do so.
Okay, we have one question from Nick. Nick, thank you for your question. Nick's question is, can I still contract under the JCT 2011 suites? So a simple answer to that is yes, you can. The 2011 suite will be available to be downloaded and used until April 2018. After this period, the transitional period for use of the 2011 suite will come to an end. However, we would recommend that you use the 2016 suite for any new projects with a bespoke schedule of amendments. This is because the new 2016 suite have been amended by JCT to reflect the current legislation and case law, so it's always good practice to use the most up-to-date standard forms of 2016 contracts.
We've also just had a very quick general question about the slides, and I will say that they will be coming out to everyone who has attended by email. So if you haven't been able to get your hands on a copy yet, they will follow. So don't panic; they're coming your way, and you'll be able to refer back to them as and when necessary. And as we've said before, our contact details will be on there. So do feel free to get in touch with us by email if you do have any further questions that you'd like to ask, and we'll be happy to respond. I'm not seeing any more questions coming through, so we'll wrap up now. As I've said, if you didn't get time to ask anything, do just drop us an email once the slides have come round. So just to say thank you very much for taking the time to join us from both myself and Victoria, and all the very best to you all.